Hey, my trendies, trendsetters, and my trendy tribe. Let's get caught up a little bit on Kevin Hart versus Tasha K. And as I put in my thumbnail, I do believe some points that were raised in Tasha K's arguments could apply for some future use for the people that are trying to not let us talk about some things when it comes to their reality. So I just wanted to show it. Obviously, it's state by state on what laws can apply. So this is not a catch-all, but it is very interesting on the points that she chose to raise against Kevin Hart applying for this ex parte temporary restraining order. So first, let's look at his application for the temporary restraining order. Okay, so this was filed January 25th, 2024. And it says plaintiffs Kevin Hart and K Hart Enterprises, collectively plaintiffs, hereby apply ex parte for the following relief. A temporary restraining order against defendants Maisha Shakes, that was his former assistant, Latasha Transrena Kibi, that's Tasha K, Kibi Studios, and Yellen Entertainment LLC, collectively defendants, and each of their agents, employees, reps, or affiliates, to enjoin, pending further order of this court, the defendants from any further publication of the interview that Kibi conducted with Shakes and published on her website on December 22nd, 2023, and of any related content regarding Hart. And B, in order to show cause requiring defendants to show why a preliminary injunction should not issue, enjoining defendants from any further publication of the interview and of any related content regarding Hart, as set forth in the concurrently filed proposed temporary restraining order and order to show cause reissuance of preliminary injunction. Plaintiffs have suffered and will continue to suffer irreparable harm from the continued publication and broadcasting of the interview and related content, which includes defamatory statements, including false statements regarding Hart's supposed criminal conduct, which are damaging to his reputation and thereby to his livelihood as a performer, as well as statements regarding personal and employment information regarding employees at Hart-affiliated companies. Legal remedies, including monetary damages, would be difficult to quantify and otherwise inadequate to compensate Hart for the ongoing and irreparable harm he is suffering. Hart and Shakes are parties to an NDA, pursuant to which they stipulated to injunctive relief in the event that Shakes breached that agreement, as has occurred. Plaintiffs are providing proper notice of this ex parte application to defendants. The application will be served along with the summons, complaint, and other case initiation documents upon defendants Kibi and on Kibi Studios through its registered agent Kibi. The application is based on the first amended complaint filed in this action, dated January 19th, 2024. Okay, so let's get into Tasha K's opposition to the ex parte. It's always shots fired every time, but y'all, when y'all see this one statement within the argument, I'm like, wow, wow, wow. The attorney, I guess, was on the same time because the way that they worded this, they knew what they were doing. Okay, so this is the defendant Yellen Entertainment LLC's opposition to plaintiff's ex parte application for temporary restraining order and order to show cause reissuance of preliminary injunction. Introduction. Plaintiff Kevin Hart is a celebrity and the star of, among other movies, the Jumanji films, Captain Underpants. And again, y'all, this is how it started. He's the star of, and then they put in the 2017 SEX tape that famously co-starred someone other than his wife. They chose, you know what? That 2017 SEX tape was the subject of national news coverage at the time and the subject of a widely reported lawsuit in this court. See, I'm going to say Sabaj versus Hart. See also Hannah Yasharov. Kevin Hart faces $60 million lawsuit over 2017 Las Vegas hotel room recording, USA Today. Jamie Burton. Kevin Hart's SEX tape lawsuit to go to trial, Newsweek. Francesca Bacardi. Kevin Hart alludes to SEX tape extortion, quote, mistake, quote, is human, page6.com. This action and Hart's urgent request for a TRO arise out of his objection to an interview of his former assistant, Maisha Shakes, published on December 22nd, 2023 on Tasha K Live, a news and entertainment program produced by defendant Yellen Entertainment and featuring defendant Tasha K. In the nearly 1.5 hour interview, Kibi and Shakes discuss, among other things, Hart's sex tape, the public controversy surrounding and arising from its release, and Shakes' theory, the reasons for which she disclosed in the interview that Hart filmed the footage. They also discussed the legal claims filed against Hart by the woman in the video, referencing the charges she alleged in her lawsuit. By his own admission, Hart has known about the Shakes interview for at least 2 months, and they have that in all bold. He claims that he was alerted to the interview before it aired and that his lawyers sent Kibi and Yellen a letter as early as November 22nd, 2023, demanding that they refrain from publishing it. Tasha K Live aired the interview on December 22nd. Hart and K Hart Enterprises, Inc. filed this suit on December 26th. Still, Hart waited until January 19th, 2024 to ask the court to issue an emergency ex parte TRO granting an extraordinary mandatory injunction that would, 1, require Yellen to remove the entire nearly 90-minute Tasha K Live episode and related promotional YouTube posts, and 2, prohibit Yellen and the other defendants from any further speech or publication, not only about the interview, but also about any related content or any other statements regarding Hart. The court should deny this request. Hart's delay in seeking preliminary relief is reason enough on its own. Even if the court were to look past his unexplained delay, Hart has not carried his burden of showing entitlement to a TRO. Most important of all, the court should reject Hart's request because his proposed TRO is flatly prohibited by the First Amendment to the U.S. Constitution and by Article 1, Section 2 of the California Constitution, which provides, quote, an even broader guarantee of the right of free speech and the press than does the First Amendment, end quote. Accordingly, and for any further reason that may be raised at the hearing on Hart's application, Yellen respectfully requests that the court deny Hart's application for a TRO and deny his request for an order to show cause why a preliminary injunction should not issue. Number 2, the argument. A. Hart cannot carry his burden to obtain a TRO. To obtain any preliminary injunction, expedited ex parte or otherwise, Hart must demonstrate a likelihood of success on the merits and establish that the balance of the risk of possible harms weighs in his favor. Hart cannot do either. First, Hart has not demonstrated a likelihood of success on the merits of his claim for defamation, the alleged harms from which are the sole basis of his TRO. Hart objects to the suggestion that he filmed a SEX tape and the reference to charges that were plainly referring to civil claims that are a matter of public record. He has not alleged, much less shown a likelihood of success in proving that these statements were actionable statements of fact versus protected opinion, that they are provably false, or that these statements, rather than the years of coverage of the SEX tape and legal claims against him, caused him harm. This is to say nothing of fault. Hart concedes in his ex parte TRO application that he must prove actual malice, but his only theory that defendants should have investigated further before publishing ex parte app at 13 has been rejected by the Supreme Court as insufficient. See Hart-Hanks Communications, Inc. versus Connaughton. Failure to investigate before publishing, even when a reasonably prudent person would have done so, is not sufficient to establish actual malice. That's the statement that I'm referring to when I say this possibly in the future could help certain content creators. I'm not saying it will. I do not have a legal background, but it was very interesting that they cited this case. So again, the statement that caught my eye was failure to investigate before publishing, even when a reasonably prudent person would have done so, is not sufficient to establish actual malice. Second, he also cannot show that the balance of harms weighs in his favor, despite insisting that he has already suffered irreparable harm that may increase. Hart has not identified any actual harm that he has suffered or that is imminent or ongoing. He only speculates that the publications might harm his reputation or that they might impact professional agreements if his reputation declines. This is insufficient. To the extent Hart argues he has already been harmed, the TRO cannot cure that alleged injury. The parts of the interview that Hart challenges discuss allegations already in the public sphere and are themselves now also in the public. And as noted above, Hart's delay in seeking to silence that publication is grounds to deny his request on its own. By comparison, as explained below, Yellen and the other defendants have a First Amendment interest in exercising their right to speak about matters of public importance. Hart's proposed TRO would unconstitutionally infringe on that right. The ex parte TRO application should accordingly be denied because Hart has not established the grounds for issuance of a TRO or an order to show cause why a preliminary injunction should not issue. B. Hart's proposed TRO is an unconstitutional prior restraint in violation of the First Amendment. Because Hart seeks an order prohibiting a party from making or publishing statements about the interview and him, the requested injunction would be a classic type of an unconstitutional prior restraint. Prior restraints are disfavored and presumptively invalid. Moreover, under the First Amendment to the U.S. Constitution and Article 1, Section 2 of the California Constitution, prior restraints are not permitted to stop the publication of an allegedly defamatory statement unless and until the question has been finally adjudicated. An unbroken string of cases from the United States Supreme Court and California Supreme Court have found that prior statements are nearly impossible to justify, or prior restraints are nearly impossible to justify. It has been consistently held that any prior restraint on expression bears a heavy presumption against its constitutional validity. Only exceptional cases akin to the revelation of the sailing dates of transports or the number and location of troops in a time of war could justify such an extreme remedy. The standard is so difficult to meet that the United States Supreme Court has never upheld a prior restraint against the press. Gilbert is particularly instructive. Plaintiff, a well-known actor whose personal life has been the subject of numerous articles, sued a tabloid newspaper for defamation, conspiracy to defame, invasion of privacy, and more based on an article that reported accusations that she was a deadbeat mother, among other things. Seeking a restraining order and preliminary injunction, the actor also alleged that the source of the article's accusations, her ex-husband, also defendant, threatened to reveal more information unless she dismissed her claims against him. The trial court initially granted the injunction, drawing distinctions between threatened disclosure of private information and constitutional free speech issues as disparaging celebrity news and gossip, just as Hart has attempted to do. The Court of Appeals disagreed and reversed the injunction, applying well-settled First Amendment principles and emphasizing that the California Constitution provides an even broader guarantee than does the First Amendment. It concluded that while a defendant may be held responsible for AB using his right to speak freely in a subsequent tort action, he has the initial right to speak freely without censorship. The same conclusion must follow here, where another actor claims allegedly false or private facts have been improperly disclosed, whatever the merits of Hart's claims, and Yellen disputes them in their entirety. Hart simply cannot obtain the preliminary relief he seeks. For the foregoing reasons, and any further that may be raised during the hearing on Hart's request, the court should deny Hart's ex parte application for a TRO and order to show cause reissuance of preliminary injunction, dated January 24th, 2024. And here's the court's ruling. It says, to all parties and their counsel of record, please take notice that on January 25th, 2024, the court held a hearing on the ex parte application for temporary restraining order and order to show cause reissuance of preliminary injunction, ex parte application filed by plaintiffs Kevin Hart and K. Hart Enterprises, Incorporated. After considering the parties' written submissions, the pleadings in this matter, the parties' argument at hearing, and relevant legal authorities, the court denied the ex parte application and entered the minute order included as attachment 1 to this notice. The matter is called for hearing. The court, after reading and considering all moving party and opposing party papers and arguments of counsel, makes the following ruling. The ex parte application is denied. Moving party may file a noticed motion for preliminary injunction in the assigned IC courtroom. Counsel for defendant is to give notice. So there y'all have it on the arguments presented to the court on why the ex parte temporary restraining order should not be granted. The court actually ended up denying doing the TRO, which means for now, Tasha K can keep up everything related to Kevin Hart in the interview with Maisha Shakes. Now we're going to get into Charnita's world. All right, so let's watch the Charnita's World trailer just to refresh our memories. We played it a couple months ago, but now it's coming. It's coming this Friday, February 23rd, 2024 at 9 p.m. Make sure you go to nubiantv.net to check for your actual local time. But I can't wait. I'm so glad it's on a Friday night because my inner seasoned woman likes to go to bed early. So this way I can at least try to sleep in if I'm able actually to stay up and watch it. I can't wait to see the content creators' reviews of the show. Again, I want to reiterate, Melody asked that we give this the Love and Marriage Huntsville attention treatment. So that shall be done. This show is produced by Melody Cherie's production company, Tilted Crowns Productions, and it is a project that she has with Dawn Michelle, her manager on this one. So shout out to them. Shout out to Charnita's World. And then, all right, let's look at the trailer to refresh our memories.
Charnita Horton comes with so many avenues. I do a lot and I have to balance a lot. They're gonna know I'm bringing it to the city, Birmingham, Alabama. Tell them who you are and what you're doing. And big announcement.
We're the family next door. It's some added flavor. You can be a little extra, but it's all in fun.
Charnita's World, we shooting a reality show.
Right, I understand all that, but let me get you to step out the car.
Okay.
Y'all stay back. I understand you say y'all doing the movie, stay back. But we literally had to work to get to where we are.
Yes.
This is Charnita's World, but I make the world go around.
Jason giving a baby swim lesson.
I almost drowned. Not one time, but it's been a few times just because I didn't know all the fundamentals, all the techniques of swimming.
Because you told the particular student, you black and pretty, but I want you to fully understand why your hair look different, why your color look different. So how's moving going?
Our employees are amazing.
They going good, Jason. They were trying to get rid of your clothes.
They understand our life. They understand us as owners. Each owner.
You already know Birmingham, like anything can happen.
Right.
But I would have never known with Chanel, I would be the one to be targeted.
She decided to bust me in the face.
So all of a sudden, she literally went around my face and bust me in the face.
I'm also excited with Charnita because it's hard to get her to work out.
We're gonna take it easy, light workouts. I have been trying to get Charnita to work out for months.
For my lupus, my joints, I can't bounce too hard. So,
Ready? Okay.
yeah, and I do not like working out. Hey, girl.
Yeah. I'm gonna get everything set up for you.
Yeah, y'all know I have lupus. People really don't know what you go through. And dealing with these players that I have to get sometimes every week, and this one in particular.
And y'all, I just appreciate her. She explains to me everything that I'm going through.
Everything is about solution, but it was just the thought. My name is not on this bank account. They kissing me all the time, and I love him and all. But it's time for me some ladies' time. I decided I wanted to go to ATL. We ate good, we felt good, we sipped just a little, and we just talked and we grew, and I just felt so free. Welcome to another episode of Green Tea Talk. What is too much? Like what?
Me.
Ooh.
Me, I'm too much. And I'm okay with being too much.
Mm-hmm.
Because somebody gonna buy that too much.
Okay.
And somebody can't afford that too much.
I'm embracing how I feel, and hey, it's Charnita's World.
Thank you for watching the trailer again. So y'all see that they have a lot going on this season. That police officer said, I don't care. I know y'all filming a movie. Who hit Charnita? That was crazy. Love seeing the self-defense class. Love seeing the children being able to or being taught how to swim. I'm just excited for the season. I feel like there's going to be a lot. Her lupus journey, her, their small business journey, all the things. So I'm ready to be here for it. I'm going to be, I don't know, I'm just rooting for the show. Obviously rooting for Melody Cherie as well. And let me know what y'all think about it. Are you ready for Friday? Let me know also what you think about what we went over with the Kevin Hart versus Tasha K and the arguments presented by Tasha K's attorneys, because that was very interesting in my opinion. All right, talk to y'all later. Bye.